Good evening, everyone. Welcome to the first of what we hope will be many webinars that SPDR and JustAct will organize on a variety of topics, primarily focused on ADR and ODR. Today we have two fantastic speakers, Harish Narasappa and Siddharth D'Souza. May I welcome Uma Ramanathan to please introduce the speakers and say a few words, and after which we'll just start. So for a few minutes, ma'am.
Thank you, Karthik. It's indeed a privilege to start this web series, because for some time we were thinking about how to spread the message of dispute resolution. As the word itself says, resolution is RE, then solution. So it could be with respect to solution or change the way you look at the solution. So when I was looking at that, we were thinking that there is a lot about information management today. And that's how we got to collaborate with JustAct. And we thought we would have a platform where we could do some constructive dispute resolution. We had programs for training and for mediation lined up. And at that time, this COVID came in, and then we had to rework the whole thing. And it looks like ODR is the way that we can move forward today. When we started this virtual thing, we were looking at only two things. What is the security aspect of it, and what are the kind of expectations that are attached to it? And so obviously seamlessly it moved into this topic about opportunities and challenges, because there has been a paradigm shift in the way things have changed about how you handle your life, about how you handle your conflict, about how you handle your relationships. So I'm really pleased to have two very good speakers with us today. The first is Mr. Harish Narasappa. I'm sure he doesn't need any introduction, but then just to say a few words about him, because without that, it wouldn't be right to start the session. He's a lawyer with extensive experience in advising on cross-border mergers and acquisitions, banking, corporate, finance, private equity, projects, regulatory, and dispute resolution matters. He's also very active in the Karnataka High Court in the social interest litigation area. Harish is also the co-founder of Arbitration, now an end-to-end online dispute resolution platform. He's also a co-founder of Daksha, Bengaluru-based independent, not-for-profit organization that uses cutting-edge technology to solve various problems facing India's judicial system, which I think all of us will agree is the need of the hour. Daksha has built India's first public database on the judiciary. So with his knowledge, he's the author of the book Rule of Law in India, A Quest for Reason, published by Oxford University Press. He's a joint editor of Daksha's pioneering reports, State of the Indian Judiciary, a report by Daksh, Approaches to Justice, a report by Daksh, and Justice Frustrated, the systemic impact of delays in Indian courts. So obviously, when we look at this kind of a profile, we think, yeah, it is not only domestic, it is cross-border. And then how are we going to get these parties who are in dispute to come to the same platform to talk about it? And that is where we have our second speaker, Mr. Siddharth D'Souza, who is the founder of JustAct, a law and design social venture, and is a postgraduate researcher at the Department of Law, Technology, Markets and Society, Tilburg University. Both of them have been brought together by Karthik Narayan, who is, in essence, a people management skill and decisions management skills person, who thinks that everything is possible if you put your mind to it. And I think that's how the series has started. So let's start with a bang. Over to you, Karthik.
Thank you, ma'am. So let me just set the context in a minute or two, and then we'll have the speakers speak. The format will be thus: Harish will first speak. I would say for the topic, which is opportunities and challenges to ODR, and I think he's going to talk more about the opportunities. And we'll then have Siddharth take the counterpoint and talk about the challenges. And Harish and Siddharth, you may take the stage for 15 minutes each, and then we'll probably be left with 25 minutes for Q&A. I have a bunch of questions, and then obviously, if anyone has questions, please post them in the chat. And then I will kind of schedule them and try to push in as many of the questions as possible. So we'll look to wrap this whole thing up by 6:30, 6:35 max. So that's the plan today. So just to put a little bit of context to what we're trying to talk about here, I think I'm obviously pro the motion. I'm kind of gung ho on JustAct, but I think on ODR, but I think we need to also see the counterpoint here. What's actually happening, I guess, if you look at the world in general, there's massive concentration of wealth and intellectual property, which means that there are going to be very few people who hold a lot of power and a lot of people trying to oppose them. The services economy is dominant as compared to the manufacturing economy, which means that more and more businesses are touching people individually. The government, which is known to be one of the largest litigant, is only getting bigger in the world thanks to COVID. They're spending more money on infrastructure. Balance sheets are getting bigger, and so they're even getting bigger. The left seems to be coming back into some form of shape and power as of the US elections. And finally, privacy issues are seeming to take a big center spot in a lot of the discussions and the narrative in the world, thanks to cloud-based services and so on. All of this means that we are coming into a very, very polarized world economically, socially, and politically, and from a business perspective. And courts' capacity are limited to deal with this kind of polarization. And so, obviously, I feel that we need another form of resolution, which could be ADR or ODR. But I guess we want to let Harish and Siddharth now talk about their points of view. So Harish, I welcome you warmly to this session, and I'd like you to take the stage and talk a little bit about what do you think are the opportunities for ODR.
Thanks, Karthik. Thanks, Ms. Ramanathan, for that very kind introduction. Thanks, Karthik and Chitra for inviting me to this, webinar. So when Karthik told me, you'll have, or he mentioned just now that you'll have 15 minutes, I was thinking, oh God, 15 minutes, what will I say in 15 minutes? But then once he said the context, I was thinking, Karthik, 15 minutes is not enough, I need 1 hour. But anyway, I'll quickly make about 4 or 5 points to explain why I believe that online dispute resolution methodologies are something that we need to embrace and very rapidly, but not at the cost of sacrificing the principles that underlie our justice system. For example, things like natural justice, fair hearing, and all the other safeguards that we have. And why do I say this? So I don't come to this ODR platform from a technology perspective. I come to the ODR solution from the justice system perspective. And I'm only talking about India today. I won't focus on other countries. If we look at our justice system, our judicial system, there are several challenges that that the judicial system faces, and we are stuck in a system which is not delivering justice on time to give relief to the people whose rights are violated. On an average, and these are all numbers that all of you know, on an average, even a single, at every stage of our judicial system, that is, the district judiciary, the high courts, and the Supreme Court, on an average, it takes about 5 years. So you're looking at a case life cycle of about 15 to 20 years if your case goes all the way from the lower courts to the highest court. So we have a justice system that is that is severely crippled because of the volume of the cases. However, on a deeper reading, it is not a case of too many cases in India. It is actually a case of exclusion of people being able to access the judicial system. Because what we forget when we look at the problems of the Indian judicial system, we end up focusing on the 3 crore cases that are pending, and those are the latest numbers, about 3.15 crore cases that are pending in the Indian courts, and we all get daunted by it. But we also don't realize that, we also don't understand the reasons behind the 3 crore cases. I mean, if 3 crore cases were pending only for about a year, then I don't think that will be a problem for anyone. But if 3 crore cases are pending for 15 years, that means cases are not getting resolved in a meaningful fashion within a time frame that gives meaning to the solution, right? If a solution is, if a dispute is resolved after 20 years, it may not have any meaning. The parties who are fighting, for resolution, may say, okay, is this what it is? And I'll give you an example. I mean, and this is a case that I was reading, and I've written about it. It's a case that started in about 1960s in the Delhi judiciary and went all the way to the Supreme Court about a piece of property, and the case was pending for about 35 years. Now, this is not a unique case. It's, there are many examples of these cases. Now, what is the impact on the parties that, that are fighting this case? If a piece of property or the subject matter of a dispute is critical to the life of the individuals who are litigating, then how can that issue not be resolved for 35 years? So if you ask that central question, then it is very clear that we need to do something about getting our judiciary and judicial system to function better. And what the way forward, and if you look at the number of courts, the number of cases that are coming to the system, and the capacity, we are clearly challenged. We cannot build the infrastructure that is required, the physical infrastructure that is required to deal with the number of cases that are coming up fast enough. The capacity to deal with the cases in a timely fashion just doesn't exist at the time. So you have to find new methodologies of resolving this. So one way of doing it is to use technology. And it is, Ms. Ramanathan and Karthik both alluded to how COVID has made this a different world. And one of the good things that has come out of COVID is the adoption of online hearings by judges. There are severe problems with the way that it has gone on, because not all pieces of paper are online. So courts still need the physical infrastructure, but only the hearing is happening online. So if you're looking at A, solving the capacity problem, and B, solving the access problem in the Indian judicial system, then we have to think of new ways of resolving disputes. And what is that way? It is to essentially make sure that the reach of the dispute resolution mechanism goes beyond what currently exists. And that can only be done when you're able to access the dispute resolution mechanisms, from wherever you are, from not being able to, from not finding it difficult to go to courts, or not being constrained by the lack of physical spaces that exist. So that's the first point. Second, in terms of empowering the key personnel in the dispute resolution mechanism, which is judges, arbitrators, mediators, and so on, to be able to work more efficiently, to be able to interact with all the stakeholders more efficiently, without the problems of travel, the problems of availability, the problems of coordinating accessibility. I think if we are able to do all of these things in a more efficient manner, then I think we will be much better off. And the only way to do that is to use technology. And why do I say that's the only way to do it? Maybe if this kind of technology was not available, we would have thought of different ways. But given the the spread of technology that has happened in the last decade or so, I think it would be foolish to say that we will not adopt technology to improve delivery of justice. So I think it is critical that we adopt newer technologies to solve problems of justice. So I would like to end by saying I do not see ODR as a different mechanism from delivering justice. I know ODR is a very vague term at the moment. While there is meaning for ODR, online dispute resolution, but what falls within the realm of ODR is something that people are discovering still. And therefore, I would like to caution that we need to look at the possibilities for ODR in the context of each country. So as a nation in our country, our judicial system faces challenges that doesn't exist anywhere else in the world. We have challenges in respect of access, in respect of capacity, in respect of delays, in respect of backlog, all of which affects the rule of law in our country. So we need to fix this problem quickly. I'm not saying ODR is the only solution and it will solve all of these problems, but ODR is a significant a step forward. If we enable our judiciary and our legal system to adopt technology much quicker and make them digitally native to enable access to justice, then I think we will be in a good spot in resolving some of the challenges that are facing our judicial system. So I will stop there. I'm sure there'll be many questions which we can come to later. Thank you.
Thank you very much, Harish. So I'd like to invite Siddharth D'Souza to speak on the challenges or whatever he feels is against the null hypothesis that pretty much all of us are thinking here, that ODR is the solution. So Siddharth, over to you.
Yeah,
please.
Thanks a lot, Karthik, and thank you, Chitra, also for this invitation. It's a great opportunity, and I look forward to discussing with all of you. Thank you to Ms. Ramanathan and also Harish for those thoughtful remarks. So what I'm going to try and do here is, in terms of how I want to see the topic, like Harish, I don't come from a technology perspective, but I'm interested in questions of access to justice, as well as interrogating what the design of ODR really is, and how does this sort of raise questions for equality, equity, fairness, transparency. And these are questions that I'm going to try and address in the course of my remarks. But before I begin, I'd like to connect a little bit to what Harish said on the term ODR itself, which, as he mentioned, is vague. So one of the things that I tried to do is to look at how ODR is also defined in the recent draft policy by Niti Aayog, which says that ODR is not just technology integration, but where technology is actually used to actually solve disputes. So what this means is that ODR is not just, say, virtual scheduling of cases. It's not just video conferencing. It's not just document circulation. It's not just, it can also include automated decision making. So with the use of artificial intelligence and machine learning. So what you have here is you have an entire life cycle of a dispute that potentially will go online. And when we actually interrogate whether ODR actually enhances or furthers access to justice, we have to look at it from all these different perspectives, from the perspective of circulation of documents, scheduling, video conferencing. All of this sort of raises questions for access. And when we think of a life cycle of a dispute, we think of it in terms of legal awareness. We think of it in terms of dispute avoidance, dispute containment, dispute settlement. So what I want to do today is to really think about, when we're thinking of this life cycle of a dispute and the potential of ODR, we need to ask the question is, who are we designing for? So I would like to take a sort of human-centered approach to this topic. So the first question that I'd like to ask is, why are we building ODR platforms? The second is, who are we building this for? The third is, what are we building? Are we building a platform? Are we building a community? Are we building a technology? Is it a service? And I think one of the recent debates from Richard Susskind is that court may not be a place, but court is actually a service. So are these ODR platforms actually a service? And are we building these services actually based on the problems that people face? And if so, what are the key issues that they have? So how have we centered this whole ODR discussion? And Harish gives very interesting arguments on the question of cost, the question of time, the question of efficiency, which are central to also how we think of how a justice system functions in India. And I would also like to take that further and also ask and make a distinction between access to justice as well as access to courts or access to ODR. But before that, given that a lot of this discussion on ODR and virtual courts has got an impetus because of COVID, an example that struck me was when you think of it in terms of users and what we are building was from Kenya. So similar to us, they could not have physical hearings for reasons of safety, for reasons of health. So they needed to create a justice and continue to allow people to go to courts to resolve their disputes. And they tried going online, and that was the first way they went forward. And they realized there were questions of access in terms of internet, electricity, smartphone devices. So what they did was they actually had a temporary solution of open air hearings. And the reason I mention open air hearings is it still met the need of allowing people to come to court in a familiar way, with familiar procedures, with familiar locations and geography, and even the socialization of a court. And yet they did it in this open air manner. Now, of course, this may not be a long-term solution, but what I want to emphasize is, if we are to think of building systems from the perspective of users, then in this instance, they realized that people still needed to get their disputes resolved by courts, but they just did not have the apparatus and the infrastructure to do so. So when we are thinking, and this brings me to my next point, is when we are actually thinking of access to justice, are we thinking of access to ODR, or we're thinking of access to justice? And I'll say why this is different. Because one of the questions that often comes up when we think of dispute resolution is how many disputes actually go to court. And this is something that Harish mentioned as well. People do not always go to courts to resolve their disputes. They will go to their families, they may go to neighbors, they may go to customary tribunals, religious courts. And I have an interest also in legal pluralism, which actually is the idea that there are multiple ways in which people resolve their disputes. So in the work of Miller and Sarath, they have this idea of a dispute pyramid, where only a small proportion of cases actually go to court. But in further research, they actually came up with this idea of a dispute tree, because disputes can go in different ways. So the question that I think we need to ask is how many disputes are going to go to ODR? Are they going to go there voluntarily? Are they going to go there because there's no other opportunity? So what are the different kinds of pushes and pulls that will make people actually use ODR? And is this something that we need more information on? Is it only going to be backlog of cases? Is it only going to deal with questions of time and efficiency or cost? How are we actually going to ensure that ODR is seen as a legitimate solution beyond just courts? Also, people would rather go there than resolve their disputes outside court. And this brings me to the point that when we think of access to justice, are we thinking of access to justice from a supply side? By which I mean, are we thinking of access to justice in terms of the institutions? How do we get our institutions to work better? How do we make the institutions more efficient, more affordable, more time sensitive? Or actually, are we thinking of access to justice in terms of people, in terms of their lives, their experiences, their opportunities? And I think that the question of experiences is important because in a country like India, which is so diverse, we have to actually think of access to justice in terms of how it's realized in ordinary people's lives. And this is why in the next part of my presentation, I want to actually focus on a demand-centered approach to access to justice, and by that, also think of ODR. And in this regard, the first point that I want to talk about is the question of ability. Do people actually have the ability to go to an ODR? Are they able to articulate their disputes? Will this setting actually allow them the same security, safety, familiarity? Will it be impersonal? Will it just be a tick box? Will it be a text? How do we ensure that there is an ability? And if there's no ability, who is going to create this kind of capacity? In a lot of the research on ODR, the question of trust emerges. And I think this is a central argument. We cannot build a system without actually focusing on the ability of people. The second thing that I want to talk about is opportunity. Do people actually have the opportunity to go to ODR? Yes, it may be faster, it may be more cost effective, but if I don't have internet, electricity, and a smartphone, what's going to happen? So do we actually have the opportunity? And this is a question that we need to sort of layer and actually identify. Are we building a platform that caters to the context that we are working with? If not, we can of course build it for a particular type of case. But if we are building it across the board, what are we taking into account these very disparate experiences that people have when they resolve their disputes? The third is the question of agency, and a lot of the discussion has been using an opt-out model, so to actually push people towards mediation and settlement. But if we are having this opt-out model, what is the question of power that exists between different parties? If someone is compelled and the process of opting out is so complex, do we actually consider the power dynamics between the two parties, and is one of the parties forced into settlement? I think this is also a question to consider. The next, and I think this has been mentioned, is about the accountability and transparency of the platforms. So the reason why I gave the definition of ODR in the beginning was also to say that it is this amorphous, broad definition. So for instance, if it is also to include automated decision making, then what are the kind of safeguards that we have to actually understand how algorithms work? Is this going to be free and open source? And if so, how does that work when there are private players? Do private players also have an obligation to make their algorithms public? And what happens to proprietary information? So I think this is something also to consider. And the second point is also, and I think this is a discussion that emerged when we talked of virtual courts, is what happens when proceedings are not live streamed? Is there actually a democratic deficit where journalists, where public cannot actually participate in these hearings? So when we do create an ODR system, do we also consider the sort of democratic function of courts to be able to speak to people and question people? Beyond that, I think one of the things that I'd also like to focus on is, and again, I come from this from an access to justice perspective. So studying who are the players who offer ODR in India? How do we make a distinction between ensuring that different players have the same standards of procedure, have specific trainings for mediators or neutrals, have a model code of conduct? How do we ensure that there is a kind of standardization of processes? How do we know that across these different players there is actually a similar kind of transparency and accountability of platforms? And also this raises the point of who's regulating these ODR platforms. If it's a mix of court annexed ODR platforms as well as private platforms, how are these platforms going to be regulated? If it's self-regulation, then what is the kind of expectancy among these self-regulatory procedures that ensures that as a user, I know that there is a certain integrity to the process? One of the interesting moves that ODR has questioned is this kind of shift from not just virtual to human, in person to virtual, not just the question of thinking about something that's more impersonal than social, but also the question of confidentiality. When there is this huge amount of data that's being generated, we need to ensure that there are certain processes in place to ensure that data is anonymized. There is a time limit on what kind of data is is kept and why it's retained, and also what are the usages of the data. Is this data going to be used to feed the algorithm in order to ensure that the kind of resolutions that come up are improved? As a user, do I have the capacity to opt out at that point in time? So again, from a sort of confidentiality point, I think it's essential to ask these kind of questions. And the other thing that I think is very central for our context is also to think of the user as not as actually a multifaceted, diverse, intersectional person. There's a question of gender, there's a question of caste, a question of region, language, culture. How do we consider the intersectionality of our user when we are building a platform? And how do we consider that in each of these circumstances, the process of dispute resolution is also a social experience? It also requires empathy. It also requires connection. It also requires that this platform is able to deal with anxieties. It's able to deal with worries that users have. And this is one of the main reasons why people don't go to formal systems and rather go to systems they're familiar with, because they just do not understand how these formal systems work. So again, how do we deal with like the varied natures of our justice users? And hence, I think for me, I don't think it's a binary of ODR or not ODR. I think the question is, if we are building an ODR platform, we can't just use technology as being that the technology will immediately solve all our problems. What I think we need to do is really take a sort of disaggregated approach and think of within this life cycle of ODR, what are the kinds of questions, what are the kinds of digital divides, literacy divides, gender divides that ODR actually brings. Because while from an institutional perspective, it may reduce cases, it may result in more affordable justice, is this actually substantively and distributively also justice? Or is it just mainly procedural justice? And a good counter example is also in evaluating Lok Adalats, and in work by Karthik Krishna and others, you've seen that Lok Adalats may result in sort of quick dispute resolution, but there's also the whole challenge on whether these disputes are resolved in a way that allows people to be satisfied with the outcome, and do they only go to Lok Adalats because they're compelled to do so because they do not have the opportunity to stay in the formal system and to stay in the court system. So does ODR similarly become just a compulsion, or are people actually going there out of choice? And the reasons that I articulate is to ensure that when we think of designing an ODR platform, and as that's a discussion that's taking place, similar to Harish, I think it's important to think of access to justice as absolutely central to the design. But access to justice not from the perspective of an institution, but access to justice in terms of the perspective of diverse and differentiated justice users, because that is the context that we work in India. Thank you.
Thank you very much, Sid. That was so let me just try and quickly summarize what we've gone through in the last 30 minutes. I think the basic point that Harish raised was that today justice is delivered late, which almost means that the justice may be meaningless. That's because we have a capacity problem, and that capacity, we need a solution to address that capacity problem, and technology could be one of those solutions. And I think the main concerns that came out from Siddharth's side were, is it really providing greater access, or are the underprivileged who probably don't have access to internet or devices be able to access courts? Is there going to be a democratic process? Is there going to be good participation from the public at large in order to kind of critique what's coming out of these systems? And then there's a privacy question centering around data that people are submitting, privacy and confidentiality type questions. So with that, let me just set up a few questions to further this debate. I think it really almost seems that there is a solution, that there is a problem that needs to be addressed. Let's for a minute assume technology is the solution, which is what we're debating here. The question that Sid also raised is one of empathy that's required in building these systems, and what is the central factor that one takes to build these systems. I think the question that I'll ask first is, legal systems rely a lot on case laws and precedent that help in creating some amount of consistency in outcomes. Do you expect that ODR, especially mediation and conciliation, will threaten this consistency because there will be less people following case laws, there will be diverse outcomes, there will be different outlooks? Is that good or is that bad? Harish, maybe you want to go towards the consistency problem.
I don't necessarily agree that there is a consistency problem, because see, I mean, ultimately there is ODR has to function within the umbrella of the formal justice system, right, which is a judiciary. I don't foresee, at least in my view, I don't foresee ODR existing outside the formal justice system. And the reason why the formal justice system, through the state seeks monopoly over delivering justice is because the formal justice system, gives the guarantee of consistency based on precedents. So, and just like you have for arbitration and mediation today, not so much mediation, but for arbitration you have today, if there is a decision that has been made in variance with the existing law, then the courts are entitled to overturn that, and that will continue even with ODR. Mediation is more of a solution by consent, so the courts don't really go into precedents or whatever. And I think it's okay if, for example, different mediations lead to different solutions. I think that's okay. I don't think there's a consistency problem there, because at the end of the day, it is an issue that needs to be resolved. But we need to distinguish between pure resolutions involving money and commercial disputes and rights issues. For example, there are a lot of informal mediation systems, under various names, where in the name of mediation, discriminatory practices are continued, and that cannot be something that we should tolerate, because that raises larger questions. So I think when we talk about consistency problem, there are different ambits to that. But on arbitration itself, online dispute resolution using arbitration, I don't see a consistency problem as long as it is under the purview of the formal justice system. Mediation is as I said, is a consent-based thing. So I don't really see a major consistency-based problem. Of course, if if in the future we see human beings replaced by formulas in delivering justice, maybe that will arise. But I think we are far away from that. I know that's a concern many people raise, but I think at least in this country, I don't see algorithms replacing judges soon. Yes, in terms of smaller services like, say, e-commerce or some other, like your Swiggy, where chatbots come in and all of that, I think there may be some algorithms being used there, but I think that the amounts involved and the issues are so small, I don't think we should be worried about that at this time.
Thanks, Harish. Siddharth?
I think for me, I think there are two things. One is, yes, I think as Harish said, of course, the formal system can have an overview in terms of how the ODR platforms function, but we need to also ensure that when we're talking of consistency, we're also talking of the infrastructure that's being created. So, for instance, are the neutrals being trained in a particular way? Is there or whoever the mediators or whoever the adjudicators are, what is their kind of training? What is their background? Do they actually have a certain sense of a model code of conduct? Is this model code of conduct across the board, or is it determined per company? The point of regulation actually is directly related to this question of consistency. who actually regulates the nature of how these platforms function, what they are charging, what is the kind of substantive procedures, distributed procedures that they have in place. So we also have to think of it from a perspective of regulation. There can be a certain flexibility in terms of how these systems function, because maybe that's a way in which people will be able to make informed choices. But then we have to keep in mind that if people are making these informed choices, they're already of a certain degree of legal awareness. They already know that the antecedents of different platforms. But that may not be the case of our different justice users. They may actually not have that kind of capacity, digital literacy. These platforms may not make this information publicly available. So we have to design a platform that keeps in mind those who are most marginal to our legal system. We have to take that into account. And on the point of algorithms, here I would disagree, because I actually think the fear is real. It may be used for a small part of justice delivery, but in the US, for instance, there's a famous case where algorithms were used to test recidivism and whether people will risk again. And they found that they were using historic data, so there was actually a racial bias in terms of how these algorithms were created. So we have to ask these questions. If algorithms start to become part of how automated decision making is taking place, then there has to be an openness to how they're created and what kind of data they're using when they are developed.
Karthik, if I may, respond quickly, I think we're bringing together a whole lot of different concepts and raising the same issues about everything. I think in terms of, as I said, civil rights and fundamental rights, I don't think one can disagree with what Siddharth is saying. I mean, that is not a dispute between a pure commercial dispute between two individuals or two companies, right? So we need to distinguish the kind of disputes that are more amenable to to systems akin to arbitration or mediation, and rights, decisions on rights that have to be taken by the formal legal system, which by the judiciary, which there's no two ways about it. So if you're talking about arbitration between two parties, I fail to see what are the concerns about availability and accessibility that arise. Yes, there are unequal relationships in contracts, and that's always been the case in commercial relationships. So we need to make sure that those things are taken care of. But I don't think it's correct to conflate issues of accessibility from a civil rights perspective and access to justice versus using ODR for purely commercial disputes where it's it's a contractual relationship-based thing, because that's something that already exists today. It's not something that's being invented for ODR, right? ODR is just a different mechanism to do what is happening today already. The fact is, in this country, we have not been able to deepen arbitration because we don't have institutions that have been able to manage arbitration, and we are stuck in this sort of what is loosely called ad hoc arbitration, which has caused more problems than make arbitration popular. So I think there are different aspects of the same problem, and I don't think it's correct to paint everything with the same brush. I shared many of the concerns that Siddharth raised when it comes to access to justice, but I don't necessarily share them when it comes to other types of disputes.
One of the questions that's kind of coming up is how do you equate ODR, we talk ODR in a limited sense of arbitration and mediation and conciliation, but do you consider virtual court hearings also ODR, and how would you think about
that? Was that to me? Sorry, or Siddharth?
Go for it, Harish, and then Sid can respond.
See, so let's play out this scenario, right? I don't think you know. I don't think virtual court hearings are or ODR in that way, because it's, there is no change in the decision-making process. There's no change in the in how parties contest their rights. What is changed is where you or your lawyer is sitting and addressing the court. And what the experience of the last 8-9 months in India has shown is that um, uh, there are, and Daksh has actually done a survey, and they had a discussion on this about 5 days ago. So this is not 5 days ago, about 2 days ago, and there are some concerns. There are some lawyers who have not been able to access the virtual hearings. There's problems of connectivity and all of that. But also, you could imagine a scenario that where our justice system would have been shut for almost 1 year, and it was shut for about 2 months, where there was no access. Even now, there are many district courts that are not functioning to the full extent. So, where you've used tools to to continue the justice process, I don't see a problem with that. And nothing has changed except where you're sitting and addressing. And yes, there has been to some extent a disproportionate benefit to lawyers who have the infrastructure and are able to address the courts easily, as against lawyers who don't have it. But that is a question of capacity again, in which we need to address.
Yeah. Yeah. So no, I think just briefly on the previous point, I totally agree that we need to make differentiations on types of cases. And I think a lot of the concerns are that, are we building an ODR platform that works across the board? We need to be able to differentiate questions of privacy, think about power, think about question of confidentiality in sort of specific settings. And I think that's why it's important to sort of raise these access questions, because ODR is being used in very different circumstances and not just commercial disputes. It's used currently, you have online lok adalats. And for instance, in the Netherlands, you had an online divorce platform where actually questions of access, questions of power, questions of consent came up, and the platform was found to not actually be able to meet some of these concerns. So you have to, so I think the question, and I see both of us in agreement that we have to be specific about what kind of technologies for what kind of cases, what kind of standards for what kind of cases, what kind of conduct for what kind of cases. So it isn't a one-stop solution. It really needs to focus on the context in which the users are when they come to these particular disputes, because otherwise it cannot just be a one-stop solution. And I think that's something that we need to think about. Sorry, if you can just tell me the second point.
Harish's point? Or?
Yeah, this is the second question that you wanted us to address.
We weren't talking about difference between ODR and virtual court.
Yeah. Okay. I think for me, I think as Harish said, I think there is a difference. I mean, particularly in terms of how it's been adopted, virtual courts were far more ad hoc in terms of how they were adopted, and I think the kind of differentiations that Harish mentioned in terms of lawyers, access to digital infrastructure was one of the questions that actually emerged. Also, the question of democratic deficits in terms of people being able to enter into a hearing, what kind of permissions you needed to ask. So I think these are questions that actually have emerged during the last 9 months. How are journalists reporting and live streaming cases? So I do think that particularly when we are building a digital apparatus, some of the lessons from the experiences of virtual courts, how lawyers have experienced it, how judges have felt in terms of the familiarity with technology, and how users have felt in terms of suddenly switching to using a smartphone device to join in a court. I think these are questions that will also emerge when we think of ODR, because if we are thinking of it from the perspective of the justice user, then a lot of these digital divides will still be very relevant when we are thinking of ODR. So whereas I think the institutional apparatus is different, because ODR conceives of itself, at least in the most broad definition, as being end-to-end technology, virtual courts has elements that still remain offline. But for the user, I think access to the platforms remain complex and challenging, and in similar ways.
Right. So I think one of the other questions or themes that's kind of emanating from the questions that I'm seeing here, obviously there is uh, there is a big elephant in the room of whether technology is easily adopted by a lot of people. Is there a lot of design work that's involved? And I think I would like to answer that by saying, yes, it is challenging for people to use technology. There will be resistance. There will be fear to all of this. But I think let's think back to the early 2000s, or 98, 99, when we first had a Windows machine given to all of us, or a computer given to all of us. And there was obviously fear to use the computer. But 20 years hence, I think it's child's play, literally, and children are better than us in using some of these technologies. So I think there is going to be that fear. I think people will overcome that over the next 15, 20 years, and we're not talking of something that's going to overnight. But something like Google also took 20 years to be a democratic form of searching information. And so I do believe this would be the case for ODR as well. But I think if you take the technology piece out for 1 second, and we just talk about ADR as ODR, which is mediation, arbitration, conciliation, do we have the right ecosystem to even develop that? When I mean ecosystem, incentives for lawyers. So one of the big challenges that sometimes we feel is, are lawyers actually for their clients going away from courts? And do we have the right incentive system in order to address Harish's problem of case life cycle time and quicker justice system? Is the government doing enough? Are the policymakers making it easy for private players like us to actually come and say, we build a platform, or we build a bunch of platforms that people could use? So maybe those are questions that are coming. So maybe Harish and Sid, if you can just take a quick couple of minutes. We're actually running out of time, so we may have time for just one more after this, and I can even tell you what the question. It's the concept of does ODR and ADR work for criminal cases? So let's just talk about policy and ecosystem first, and lawyers, and then we'll talk about criminal cases. Sid, do you want to go first, because Harish always goes? We take.
Yeah. No, I think on the point of policy, I think there is a real. I think what's heartening is that there is it seems there is a move towards ADR, and there has been consultation. There are different partners that are speaking about it. So I think that has real potential in terms of the report that was put up, but also in terms of inviting a wide variety of responses to it. And I think in preparing for this, I saw that there were different kinds of organizations that engaged. It wasn't just justice platforms. There were technology platforms who all contributed to trying to think of what does ODR actually mean from the question of privacy, from the question of rights. So for me, I think there is a moment currently to try and build a system that can work, and I think some of the challenges that I've raised are to sort of in that regard, that yes, we do have this moment where we can build a system from the ground up, and these are further questions to think about. In terms of so I think there is an ecosystem that's growing, and there are several parties that are trying to build this ecosystem. And it's also testament to the number of new ODR platforms that have come up in India in the last year. I think that's very promising. In terms of generally looking at alternative dispute resolutions and whether lawyers support it, I'm not a practicing lawyer, so I cannot answer that question except from maybe an academic point. And I think local adalats have been around for a while, and there is a sort of disputed evaluation of them. At one point, they do help to reduce pendency in courts, and they are heralded as improving sort of the backlog in our judiciary. But at the other end, the question of substantive justice and the kind of quality of these outcomes has also been critiqued. So I think there is it requires both sides require to be told. So for me, I think one of the things, Lok Adalats also present a good case for thinking about access questions for a potential new ODR system, and I think that's one place to look. On the question on criminal cases, I think that's a tough one, and I think again it raises several arguments that both Harish and I have already mentioned about what are the kinds of safeguards that exist, both in terms of training, both in terms of accountability, in terms of the use of algorithms, in terms of like empathy, because I think this is it's central to the socialization of that dispute. So do people actually have the capacity to deal with complex solutions? There were chatbots that were used for cases of sexual harassment in the past, and I think one of the questions was, how do you actually make a chatbot sensitive to the kind of challenges that victims have to face when they go to the dispute resolution system. So I think these are challenges that we need to think about, and hence the nature of the case becomes very central when we design any system. Yeah.
Harish? Okay. Now, is the government doing enough? My simple answer is no. On the ODR platform and the mediation, there's a lot of noise and there is a lot of discussion. And Niti Aayog did hold a few discussion sessions, all of that. But justice as a whole is not on the government's agenda. And let's accept this and let's call it out. It is an orphan, right? Because either the political parties don't care, and they want to leave it to the judiciary, and the judiciary is busy dealing with the day-to-day burden they have, and they don't. Nobody is there to think about system. So the justice system today is an orphan in this country, and while there is a move, there is some discussion around ODR and ADR, but except for this new, new set of discussions on ODR and to some extent on the mediation, the proposed Mediation Act, there have mostly been, flights of fancy also, like making New Delhi the arbitration center of the world. I mean, let's get real, right? I mean, we're not able to solve our own problems, and we want it to be the arbitration center of the world. Whereas we have problems of access in terms of simple arbitration disputes. So I think there's no realistic evaluation of what can happen, and this is something that I made the point even to some of the folks in the Niti Aayog, that listen, we can't borrow ideas of ODR from other countries, right? We have to use our technology that is available here and to solve our problems. Our problems are unique. Maybe the issue of justice is not unique, but our legal system's problems today are not comparable to anywhere else in the world, both in terms of scale, in terms of size, and in terms of the the volume. I mean, partly because we are a populous country, and also there are issues, many other issues in our society. So I don't think we should. So we need to think differently. So I mean, just look at the payment space, right? I mean, India's technology is so different from the rest of the world. We have leapfrogged X, Y, Z, etc., etc. So we need to think differently. And unfortunately, because it is justice, it can't only be done by the private space. I mean, the government has to be involved. And so coming back to the question, Karthik, the government is not doing enough, partly because there's not too much attention being paid to the issue of justice as a whole. Merely taking ODR and saying, okay, we'll push ODR is not going to work. I mean, you have to set it in the context of the broader justice system. So that is the first point. On the criminal thing, I'm very, very clear. I don't think we should have any sort of algorithms replacing judges in the criminal justice system on the basis of what we have seen today. I don't want to guess what's happening in the future, because we should not forget, what does the criminal justice system do? I mean, you're taking away someone's liberty, right? And that is not an easy thing. I mean, they're human beings just like you and me. So to send someone to prison is the harshest punishment that the law can impose. Of course, there are various punishments in the criminal justice system, but taking away somebody's liberty is not something we do very lightly. So I don't think we can replace judges, by any form of artificial intelligence or machine learning mechanisms in the criminal justice system. I don't. I'm very clear about that.
No, I think we're not talking about using algorithms to solve criminal cases, but I think the question is even producing a witness on an online system, those kind of things. Procedurally, do we think ADR is equipped enough to not, let's say, steal the rights of an under trial or of someone who's who's making a claim?
See, using technology, for example, to ensure that witnesses are able to depose on time, I think there is a case for it, and I think there are methodologies now to safeguard it. But there are also, for example, some courts in the country have used video conferencing facilities between the courts and the prisons, right? For under trials not to come to not to be brought to the court from 30 kilometers away or 40 kilometers away. And many human rights activists have raised questions about that, because coming to be producing an under trial in a court means something. A judge is able to see whether the guy, the person, the prisoner is being abused, for example, whereas he is not able to see that on a video conference. So there are hard questions like that which we need to address. So one of these suggestions was maybe there should be a magistrate going to the prison itself was a suggestion. So there are some hard questions around that. So we need to again distinguish, take each process and do it. I don't see a problem with adopting certain technologies for criminal trials. For example, if it's a doctor who's done the post-mortem examination, and he can participate from his hospital instead of coming 30 kilometers and wasting a full day. That is possible, and I don't see a problem with that. Similarly, a police inspector who may be transferred now from one station to another, but he was the investigating officer, and again he needs to come for 200, 300 kilometers. I don't see a problem with things like that, because that will actually ensure that the accused gets justice in a faster way. But with safeguards, and I think so there are technologies for those kind of things, but not for the delivery of a decision. I think that's what I meant.
Okay. Let's see if we can squeeze in one quick question. Harish, you conveniently avoided answering the question of lawyers, but I'll.
Lawyers? No, not convenient. I think the answer is no. Again, I think there are the very few lawyers are amenable to ODR and ADR. But I don't think it's in the context of ODR. I think as a country we have not pushed ADR properly, and I fully agree with Siddharth's comments on the Lok Adalat. The Lok Adalats hide more than what they reveal, and we need to take a hard look at Lok Adalats.
Right. I think I've seen some questions on privacy and confidentiality, and so I think one of the kind of themes that's emerging is it okay to use redacted data to improve self-learning algorithms? This is a technology-based question, but then is that akin to using case laws to solve live cases? Is it okay to use redacted data to build smarter algorithms? So for granular cases.
I think the question is okay to who? So is it okay for the user? Does the user actually have a role in terms of where their data is being used, in terms of how this data is being used? And I think I think the sort of agency of the user in terms of such processes, in terms of the use and the reuse of their data, has to be central. So I think I don't think it can be a blanket answer, because even if it's redacted, I think that there are other concerns that can come up. I mean, you can also aggregate different kinds of data, and I think so the basic argument that I would think of is that it's essential to have like the informed consent of users, and also know that this is going to be used for whatever purposes. Yeah.
Harish?
See, I think again, I think we need to see the judicial system and what it does, right? Today, cases are public knowledge. Judgments are publicly available. Judgments have precedent value, except when the justice system creates privacy settings. So there are certain kinds of cases that are not in the public domain. So, for example, let's take if I collect all the cases that are decided and reported in the Supreme Court cases journal, and derive ensure, or rather derive algorithms that predict what kind of decisions can be made, I don't see a problem with that. But that is something that data is already available, right? And lawyers use it. This is part of our part of the certainty of the legal system already, right? But where problems arise is when you go beyond what is currently being used, and what that beyond is something we need to understand and explore a bit further. For example, I mean, let's take arbitrations, right? Arbitrations, people choose arbitration also for the confidentiality it gives people. So can you then say, okay, I will use all the data and figure out what to do? There are benefits and disadvantages, right? If it's masked data, maybe there is a benefit, and also from a lawyer's perspective, if I had access to all the jurisprudence of the arbitration decisions, it would help a lot in understanding the law. So there are various nuances here that we need to think. So there's no black and white answer. That's a lawyer's answer. There's no black and white answer. It's always a great thing. It helps all of us have a job. So so I think that's true. But the answer is yes and no. But I think we should see. And again, I would like to quote a former Chief Justice of India, M.N. Venkatacharya, who always tells me, see, what is the difference between the justice system and some other system? See, decisions are made by everyone, but the justice system offers certain guarantees to anybody who comes before it. One of which is you are heard. One of which the other is the decision is being made publicly and in the public eye. So there's no secrecy to it. So given those guarantees, I don't think the justice system should shy away from using technology to learn more from the current data, but not to go beyond what the law considers private already. So I don't, and that what is private, I know there's a separate debate happening about it on privacy, so I don't want to get into that issue here. But let's stick to what the justice system uses already and see whether that can be used to make the system more efficient.
Right. So, okay, look, I think we've come to the end of an hour and 5 minutes, and so we'll look to wrap up. I think we'll leave this session with the thought that we have a problem, we need to find a solution. Technology is an option, and probably a fairly advanced option at that. But using technology blindly, like one has in some of the other spheres is not so straightforward or trivial. Just like in the payment space, which Harish alluded to, I think the government did a huge amount of work in building what was called the India stack, on the back of which private players started building payment banks and payment systems and so on. I think we probably need something of that kind here again for private players to flourish. You need a body, a central vertebra that kind of sets the rules, sets kind of some of the procedural kind of requirements for one to be a legitimate player. There could also be some kind of a central kind of database that people could use to kind of use to proliferate technology in the space. And obviously there are bigger issues of how can you make it easily accessible? It's going to be a constant endeavor. I think we do understand that it's not going to be easily accessible for everyone to start with, but at the same time, Harish, to Harish's point, one does not need to go to courts, take a day off from work, have to pay, lose a day's salary to show up to fight a case. So I think there is a lot that one needs to do. Technology can solve the problem, but that needs a lot of issues, right, from design thinking, empathizing with customers, building the right platform, and maybe providing cheap technology for people. So with that, I think we'll call it a day. I'd like to thank Harish and Siddharth for their valuable inputs. I think this is going to be extremely personally in my journey of trying to build out an ODR platform along with my colleagues here at JustAct. Obviously, FCDR. Let me also propose a quick vote of thanks on their behalf. FCDR has been doing some excellent work in trying to proliferate mediation with 5 or 6 strong people that they have. And so, look, I think there are lots of interesting ideas that have come out of this, and hopefully and be able to take ourselves forward in this journey. So thank you very much, everyone, and we'll see you in our next edition. And a special thanks to Chitra for actually thinking of this idea and putting things together. Chitra is working on a very interesting pipeline of future webinars, and so I request you to watch out for that and then do join us for that as well. Thank you very much.
Thank you.
Thank you.
Thanks.